Hello and welcome to the Minimum Competence episode for Thursday, October 2nd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, AG James suing DHS over $34 million in MTA funds, Apple and OpenAI pushing back on Musk's antitrust claims, and new twists in Prince Harry's privacy suit. Let's remember, those who deny freedom to others deserve it not for themselves, and read today's legal news. On this day in legal history, October 2nd, 1953, President Dwight D. Eisenhower appointed Earl Warren as the 14th Chief Justice of the United States, setting in motion one of the most transformative periods in Supreme Court history. Warren, who had previously served as governor of California and was the Republican nominee for vice president in 1948, was a surprise choice appointed during a recess of the Senate following the death of Chief Justice Fred Vinson. Though Eisenhower reportedly later regretted the decision, Warren would go on to lead a court that dramatically expanded civil rights, civil liberties, and judicial power. Under Warren's leadership, the court issued a series of landmark decisions, beginning with Brown v. Board of Education in 1954, which declared racial segregation in public schools unconstitutional. The Warren Court also established the principle of one person, one vote in legislative apportionment, expanded the rights of criminal defendants in cases like Gideon v. Wainwright and Miranda v. Arizona, and reinforced the wall between church and state. Warren was known for his ability to forge consensus among justices, often securing unanimous decisions in major cases to strengthen the court's moral authority. His tenure marked a fundamental shift in constitutional interpretation, emphasizing equality, due process, and the role of the judiciary in correcting social injustices. While praised by many for championing individual rights and the rule of law, the Warren Court also faced significant criticism from those who viewed its decisions as judicial activism. Warren retired in 1969, but the legal legacy of his court continues to shape American law and society. New York Attorney General Letitia James filed a lawsuit and an emergency motion against U.S. Secretary of Homeland Security Kristi Noem and the Department of Homeland Security writ large, accusing them of unlawfully withholding nearly $34 million in funding for New York's Metropolitan Transportation Authority, or MTA. The MTA oversees subway, bus, and commuter rail systems across New York City and surrounding areas. James filed the suit in the U.S. District for the Southern District of New York, seeking a temporary restraining order to preserve the funds while the legal case proceeds. According to James, DHS abruptly reduced the funding allocation from nearly $34 million to zero, a move she described as unlawful and politically motivated. Her office emphasized that the emergency request does not seek immediate disbursement, but rather aims to prevent the funds from being lost while the court reviews the matter. She warned that the funding freeze could endanger the safety of millions of transit riders in New York. This legal action comes amid broader concerns raised by the U.S. Transportation Department, which recently threatened to withhold 25% of MTA's federal transit funding unless improvements are made to track worker safety protocols. DHS did not provide an immediate response to requests for comment. Apple and OpenAI asked a U.S. judge to dismiss a lawsuit brought by Elon Musk's AI company xAI over claims that their partnership harms competition. xAI's suit, filed in August, seeks billions in damages and argues that Apple's integration of ChatGPT into its devices gives OpenAI an unfair advantage while sidelining rival products like Musk's Grok chatbot. Apple and OpenAI countered that their deal is not exclusive and that Apple plans to work with other generative AI providers soon. Apple's lawyers emphasized the openness of the agreement, asserting that the arrangement does not prevent competition or violate antitrust laws. In a separate filing, OpenAI described Musk's legal actions as part of a broader campaign of lawfare against the company, referencing previous lawsuits Musk had filed, including one challenging OpenAI's shift from nonprofit to for-profit status. OpenAI further argued that xAI had not demonstrated concrete harm or the kind of anti-competitive behavior that antitrust law is designed to prevent. Musk, who co-founded OpenAI in 2015 before departing, has accused the company and CEO Sam Altman of straying from its original nonprofit mission. Lawyers representing Prince Harry and other public figures accused the Daily Mail publisher, Associated Newspapers, of also targeting Prince William and Princess Kate in an ongoing privacy lawsuit. The new allegations, presented in filings at London's High Court, suggest that confidential details about William's 21st birthday were obtained through blagging, a deceptive tactic to access private information. Kate was allegedly targeted by a private investigator working for a Mail journalist. Prince Harry and 6 others, including Elton John and his husband David Furnish, are suing A&L for alleged privacy violations dating back 30 years. The lawsuit accuses A&L of unlawful activities such as voicemail hacking, obtaining medical records by deception, and even burglary. A&L has denied the claims and called them baseless and exaggerated. A trial is scheduled for early 2026. The publisher pushed back in court, arguing that the claimants failed to connect the alleged misconduct to specific journalists or investigators. They also sought to exclude findings from earlier cases against other newspaper publishers like the News Group newspapers and the Daily Mirror. A&L accused 2 claimants, Sadie Frost and Simon Hughes, of manipulating the timing of story publications to evade a statute of limitations. though the court had previously ruled in the claimant's favor on that particular issue. Prince Harry attended the hearing remotely while several other claimants were present in court. This lawsuit marks the first time A&L has been directly implicated in the phone hacking scandal that has plagued British tabloids for nearly 2 decades. And with that, as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, I do not think much of a person who is not wiser today than they were yesterday.